The following segment is sponsored by Smith Injury Law and 300hurt.com.
Liability protections have been making headlines as business leaders worry about whether they would be protected from any unfair or costly COVID-19 related lawsuits, they say. Attorney Richard Smith from Smith Injury Law is here to have that discussion. Good morning.
Good morning, Margaret.
I know you're opposed to immunity from lawsuits in general, but what's the important distinction to be made here?
Well, the important distinction is that right now, employers have liability protection against their employees. For example, if you're injured on the job, your exclusive remedy is workers' compensation. So you can't sue your employer if you catch COVID on the job. You have to go through the workers' compensation system, and that's very difficult to win an occupational disease case because one of the main components is you have to prove that not only did you catch the disease at work, but that also you were at a greater risk to obtain the disease than if you were doing anything else. And basically that means your nurses and doctors, people that are involved in healthcare treating COVID patients, have a pretty good argument there, but everybody else is going to have a very difficult argument because you were just as likely to catch the disease, any place else besides just your work. So what they're talking about is liability. Really, the only place I could see them arguing for liability protection would be against like customers. Well, then again, the customer has to prove they caught COVID from that particular business, and that's going to be very hard to do. And then you're going to also have to prove that the business was somehow negligent in allowing you to catch the disease. So I think the better way to handle this would be federal assistance. Basically come out with a federal program that would both take care of people who get sick with COVID, and also if you do that, then there's a way you can limit employer liability or liability from customers and be fair. I just don't like it when companies get bailouts or get protection and the injured workers or the customer or consumer is the one that's left holding the bag.
Okay, makes sense. So tell us then, what is the best way a business can protect itself from any of this lawsuit?
Well, I think the best thing, of course, is to follow the CDC guidelines. I mean, don't just have a sign up that says mask required and then let people come in without masks. And enforce your actual CDC guidelines. Enforce the distancing and mask wearing, hand washing. If you do everything that CDC is telling you to do, it's very hard for somebody to be able to claim that you were negligent and did not provide a safe environment for a customer or something like that. So that's the easiest thing to do. That's very inexpensive, and we'll see what happens with the legislation. There's a lot of things going on about that in Washington now. But if I were an employer, I would feel like, okay, what can I do to protect myself now?
But obviously, COVID isn't your typical workers' comp case at all. What should people understand?
Yeah, COVID claim would be an occupational disease claim, just like a brown lung claim or a carpal tunnel claim that happened on the job. There's quite a few different occupational diseases that are recognized by the South Carolina Workers' Compensation Act. Obviously, COVID wasn't around then, so it was not in the act, but it would be considered an occupational disease. But most of my workers' comp claims are actual accidents on the job where a person was injured, they hurt their knee, their back, their head, their shoulder. Something happened that was an actual incident, an accident, and not a occupational disease or repetitive trauma case, but all those are part of workers' compensation.
Gotcha. And workers' comp is one main area in your practice, but tell us what else you handle at Smith Injury Law.
Well, we also handle automobile accidents, Social Security disability claims, and I can't emphasize enough how important it is. If you have a automobile accident case, for example, and there's any question of liability or it's a very serious injury, you need to get an attorney right away before that evidence disappears. That's why we've done several videos on that part of cases involving evidence preservation.
Okay, wonderful. Well, people can get in touch with you by calling 300hurt or visiting 300hurt.com. Anything else we should touch on before we let you go today?
I think that's the big issue. Just remember that whenever one group gets liability protection, you got to make sure that everybody is treated fairly. And that's obviously, a lot of people would like to say, hey, you can't be sued. But, suits are very difficult to maintain without proof, and they get dismissed very easily. So there's very few actual frivolous lawsuits out there because they get dismissed by the court, and you can pay fines and attorney's fees and costs. So the reality is, if you do everything you're supposed to do and follow the CDC guidelines, you're very unlikely to have a successful suit brought against you for COVID or anything in that type.
Great. Richard Smith of Smith Injury Law. We always appreciate your insight. Thanks so much for joining us today.
Thank you.